most important issues in this area. I think it's critical to remember that the legal analysis should begin and not end the discussion of whether to do something. If something is illegal, then obviously it's not an option. You simply can't do it. But if it's legal, then it's only that, an option. And there should be a policy discussion about whether it's a good idea. And Philip Zelikow gave an interesting talk about this, and I agree with him that in this area in particular, too often the legal analysis replaced the policy analysis. And the question tended to become simply, is it legal, and if so, we'll do it. I think that may have been understandable in the immediate aftermath of 9/11, but as time went on, it became increasingly clear that many of the steps we were taking, even if legal, had significant costs, and costs which might well outweigh any benefits we were receiving. And this is just my personal view, but I think that we in the government were sometimes too slow to recognize some of those costs and adjust our policies accordingly. Focusing on the legal analysis, I think there's a valuable process lesson to be learned from our experience in this area. The opinions I worked on benefited enormously from comments from other parts of the Justice Department and the government. And in particular, the opinion I wrote at the end of 2004 benefited from detailed comments from lawyers at the State Department and the Criminal Division of Justice, although it certainly bears repeating that any mistakes in that opinion are entirely my responsibility. There's an incredible wealth of legal talent around the government, and I believe it is a huge mistake not to take advantage of it. You won't always agree with what other lawyers have to say, but you almost always benefit from hearing it. I don't know why, but my understanding is that some of the earlier opinions were very tightly held and were not circulated for comments. I don't think that was justified by any legitimate concerns about classification or leaks. Rather, I think it was a mistake. The opinions would have benefited from broader review, and I think we paid some price for that not having taken place. I'd like to make two final points. First, there's been reporting about certain steps I may have taken in working on opinions in this area, and some people have said some very flattering things. Some have said some not so flattering things as well. But I'm not authorized to discuss that matter. But I can say that while it's always nice to have nice things said about you, they're completely undeserved. And I don't say that out of any false sense of modesty. The simple fact is I did nothing that thousands and thousands of members that were military had not done during training. I simply took the steps that I felt I needed to take in order to do the work I was privileged to be assigned. And I deserve no particular credit for that. Finally, many people, both at OLC and elsewhere in the government, contributed to the opinions I wrote. I will not name them because I don't want them dragged into the public discussion, but they know who they are, and I am eternally grateful to them. Anything useful in the opinions is almost certainly attributable to them. That said, I alone am responsible for any errors in any opinions issued while I was in charge of OLC. I did my best to answer the questions correctly, and I hope I succeeded. But to the extent there are errors in them, I am the person and the only person who is responsible for that. And in particular, if anyone in the government acted on the basis of any legal advice I gave, and that advice turns out to be mistaken, I'm the one who should be held accountable, not some agent or officer or soldier acting in good faith reliance on that advice. When someone in the government does the right thing by seeking legal advice, they should not be punished if the advice turns out to be mistaken. It's an incredible privilege to be asked to work on these issues as a lawyer for the government. We who have been privileged to serve as government lawyers are responsible for the advice we give, and I unconditionally and absolutely accept that responsibility. I'd be happy to try to answer any questions you have, but if I could just add one point. As a witness sitting there and hearing this, I feel like I have some obligation to say something about this. And I'm very limited, I think, in what I can say. But if the subcommittee has been informed that there was a total of 3 minutes of waterboarding, I would suggest the subcommittee should go back and get that clarified, because that I don't believe is an accurate statement.
I thank